at the time of death. To give an analogy, a person domiciled in France, so you have a French domiciled person, he dies, leaving behind land in Mumbai in India and movables in UK. Since the land is in India, it is not material that he was a French domiciled person, and the Indian Succession Act would apply to this person because he may not be, if he's not a Hindu, Indian Succession Act would apply. But for the movables, the law would be as per British law. Indian law would not apply to his movable property, which is not in India, but it is based in the country of his domicile. Let us now look at the Hindu Succession Act in more detail. A person dies without making a will, then the Hindu succession law applies. And this applies to Hindus, Jains, Sikhs, and Buddhists. Obviously, it does not apply to anybody who is not a Hindu. So Muslims, Christians, Parsis, Jewish are all not part of the Hindu Succession Act. And it overrides all customs and traditions. Now, Hindu law, for those of us who may remember, started with Manu Smriti. Manu is the father of the Hindu law. And he laid down the Smriti and the Shruti based on the Vedas and the Puranas. And prior to independence, Hindu law was all uncodified law. So everything was coming by customs, traditions, and rituals. Come 1947, the government decided to codify certain aspects of Hindu law. So succession, marriage, adoption, guardianship, and minority. These are some of the aspects of Hindu law which have been codified. And therefore, the Hindu Succession Act will now override all Smriti, Shruti, rituals, traditions, and it would only be by virtue of law. Even if a person who is a Hindu does not make a valid will, the Hindu law would apply. So not just died without making a will, died without making a valid will. And we'll look at what a valid will means. Therefore, very advisable to make a will or any other planning for your estate. Otherwise, law takes over. Now, in terms of Hindu law, it divides it into male and female. So let us first look at an intestate Hindu male. Intestate, as I mentioned, is a person dying without making a valid will. First, it is the class 1 heirs who get the property. If there are no class 1, then class 2. If there are no class 2, then agnates. If there are no agnates, then cognates. The order of succession is from left to right. What are class 1 heirs? Son, daughter, mother, widow, children of predeceased children, widowed daughter-in-law, all are class 1 heirs. Each of them get one equal share in the Hindu male's property. Class 2 heirs, father, sons, daughters, children, brothers and sisters, daughters, grandchildren, grandparents, siblings, etc. All of them are treated as class 2 heirs. If there are no class 2 heirs, then you go to agnates. Now, what is the difference between agnate and cognate? It's very interesting. Anybody related to a person wholly through males is treated as an agnate, and anybody related wholly otherwise than through males is treated as a cognate. Let me illustrate. My father's brother's daughter is my agnate because the commonality between her and me are two males. My father, who is a male, and her father, who is a male. So the two brothers would be treated as males, relatives, and we are agnates. But my mother's brother's son is my cognate because the commonality between us is not entirely males. It is my mother and his father. So if the common link is males, you are my agnate. If there are no agnates, you go to my cognate. Let's put practice into precept and let's look at examples. A Hindu male died intestate, leaving behind a full family. His mother, his father, his wife, that is now his widow, his son, his daughter-in-law, daughter and son-in-law. Who will get what? Mother, wife, son, and daughter. Each of them are class 1 heirs and everybody will get an equal share, that is 25% in his estate. It does not matter that the daughter is unmarried or married. Daughter-in-law would not get any share because her husband, that is the son, is alive. If he had died prior to his father, he would have got a share. Father, very interesting to note, of the deceased does not get a share because he is a class 2 heir. And while mother is class 1, father is class 2. So father gets nothing in the deceased property. And son-in-law, unfortunate soul, will never get anything in the father-in-law's estate. In the second example, you have a person who left behind his wife, his brother, his sister, son's widow, and predeceased daughter's son. Now here his wife, his son's widow, and predeceased daughter's son, all being class 1 heirs, would get an equal share, that is 33% and 1/3 each. Siblings are class 2 heirs, get nothing because once there are class 1, class 2 has no locus standi. Third example, heirs left behind are 2 brothers, 3 sisters, and mother's parents. Brothers and sisters, class 2 heirs, and therefore they would get 1/5 share each. Maternal grandparents will get nothing, and therefore it would only go to the siblings. Fourth example, father's brother's daughter and mother's brother's son. As I gave in my example, my father's brother's daughter is my agnate because commonality between us are wholly males, but mother's brother's son is my cognate, and therefore agnate would be preferred over him. The father's brother's daughter would get the entire estate. This is qua a Hindu male. What happens to a Hindu female? Now, before that, let's also look at a stepson. What if a person has a stepson? Can he be treated as a class 1 heir? In the Income Tax Act, section 2 on the definition of child includes stepson and adopted child. So would that definition be applicable even in general succession law? The Bombay High Court, the Punjab and Haryana High Court, and the Delhi High Court, and various other decisions have held no. Hindu Succession Act is different from Income Tax Act. The son as defined under General Clauses Act only applies to an adopted son, but not a stepson. Son must be a natural born son. That is, there must be a direct relationship between the person who died and his child. So therefore, legal heirs enumerated do not cover a stepson from the wife's previous marriage, and stepson cannot succeed as legal heir to the estate of a male. Very important. So if there are stepchildren, they would not be entitled to become class 1 heirs to their stepfather's property. Female intestate. Prior to independence, women, Hindu females, could not own absolute property. They only had stridan, that is the basic which they received on marriage, and they were dependent on their husband for maintenance and management. Now, Hindu females are treated as equals, and they are entitled to own property which they have acquired by inheritance, that is by gift or by will, in lieu of maintenance, partition, by own skill, that is by working, or by purchasing a property. And she can deal with this property as she likes. The Act clearly provides she can do whatever she likes with it. She can will it away to whomsoever she likes. So any property possessed by her is her absolute property. But there is an exception. Hindu law is full of twists and turns. It's like a murder mystery where you have a twist at every page. So you'll see several exceptions, and you'll see an exception to the exception, and again an exception to that. So there are lots of twists and turns and nuances. To deal with it would require a session by itself, but I'll be dealing with the important ones. Exception provides this absolute property does not apply if she received the property providing restricted right of enjoyment, and she has received it by gift, will, or by any other court decree or instrument. Now, what does this mean? This means that if the lady got the property with a limited right of enjoyment, that is, it was very clear when she got it that she can only enjoy it in a limited manner, then she cannot make it her absolute property. So what you get with a clog on enjoyment cannot become your absolute property. And this decision of the Supreme Court in Sadhu Singh is very important in this respect. There was a husband who died and he had a huge property. He gave it to his wife in his will and said that she has a restricted right of enjoyment. That is, in her lifetime, she can live in it, but she cannot gift it or will it. After she dies, it would automatically go to my 2 nephews. The wife decided to change her mind after the husband died and wanted to will it away to the Gurudwara. So she made a will in favor of the Gurudwara. The Supreme Court said, no, you cannot will away what is not your absolute property. You got it with a caveat that you have a restricted right of enjoyment. That is, you were made a life interest beneficiary. You cannot now give it away and treating it as your property. It will go in accordance with your husband's will, and it will go only to the 2 nephews. That is, you take it on an as is where is basis. You got it with a condition, you continue to enjoy it with the condition. Let's look at what happens when a female Hindu dies without making a will. Here there are no class 1, class 2, no agnate, cognate. First, it goes to the son, daughter, husband. If there are none, it goes to the heirs of the husband. If there are no heirs, it goes to the parents of the lady. If there are no parents, then it goes to the heirs of the father. If there are no heirs of the father, it goes to the heirs of the mother. So firstly, children of predeceased children and husband. Secondly, husband's heirs, as if the husband died without making a will. So here we are talking about the lady who has died, but it goes, if the husband is not there, then it goes to as if the husband has died without making a will. If there are none, to her parents equally. If there are none, to father's heirs. If there are none, to mother's heirs. If you recall, a few years ago, a very famous chief minister down south passed away. Now, the lady apparently did not have any husband, did not have any children. Hence, she did not have anyone in the husband's heirs also. Her parents have also died. Now, the question is before the Madras High Court that should the father's heir, that is a niece, or should the mother's heir, that is a nephew, who should get the property? And the court is examining who has precedent. There's not yet been a verdict on it. It would be quite interesting to see the verdict in this case. Exception time. If the lady has inherited property from her parents, father or mother or both, and she dies without any children, that is, she does not leave behind a son and or a daughter, then the property goes back to the father's heirs. This only applies to property inherited from parents. If it is gifted, then this exception does not apply. It then goes as per the normal pattern. Similarly, if she has inherited property from her husband or father-in-law, and she dies without any children, then property reverts to husband's heirs. However, if she were to leave a child in any of the above cases, then the normal succession pattern applies. So the idea is that if you got something from your father, mother, father-in-law, or husband, and there are no children, then it should go back to where it came from. If there are children, then it follows the normal pattern. Let's look at 4 examples. A Hindu female dies intestate and leaves behind her husband, 2 sons, and parents. Here, her husband, 2 sons, all 3 of them would be entitled to a 1/3 share. Parents would get nothing. Second example, she dies intestate. However, before marriage, she was divorced from her husband, and her only other relatives are her parents. Now, a divorce means a total severance of relationship. Therefore, she does not have a husband. She only has 2 parents, and each of them would get an equal share. Third example, she dies intestate. Her husband has died before her. She does not have any parents, and she leaves behind heirs of her predeceased husband. That is his brother and his sister's son. Now here we have to consider as if the husband died intestate, even though he might have made a will, but since it's the lady's property, we have to consider that the husband died intestate, and we have to look at who are his class 1, class 2 heirs, agnate, cognate. Now here the husband's brother is his class 2 heir, and he gets it in preference to his sister's son, who even though is a class 2 heir, but is at a lower preference. Therefore, the brother would get, that is her brother-in-law would get her entire property. Exception time, Hindu female inherits a house from her father. She dies intestate without leaving a child, but leaving behind her husband, father's brother, and father's sister and husband's sister. Here, husband and husband's sister would not be entitled to anything because it's an exceptional case. She inherited property from her father and died without leaving any children. Thus, it would devolve equally upon her father's heirs, that is his brother and sister. Escheat. This doesn't mean cheating. Huh? It's a legal term. What happens to an unfortunate Hindu male, female who died intestate and left behind no legal heirs? Who will succeed to such property? Would the property lie in vacuum? There is a saying in Hindi which says, "Jiska koi nahi, uska." Here I will modify it. "Jiska koi nahi, uska government of India hai." So government of India will never disown you. They will always be there for you, and they are always there to take care of you. So they are your heirs, they are your relatives. If everybody has predeceased you, government will always stand behind you and take your property when you pass away. So their property would not lie in a vacuum. Government of India will become the rightful owner of the property. However, the collector cannot suo moto take over the property. Recourse must be had to a court of law, and the court would grant a decree in favor of the government of India. Letter of administration: when a person dies intestate, his legal heirs need to apply for a letter of administration from a court. It's the equivalent of a probate when you have a will. We'll look at a probate when we come to the will section. What do you need? Death certificate as proof of death, list of legal heirs of the Hindu dying intestate, depending upon whether he was a male or a female who has passed away, likely amount of assets and estate of the deceased, application to be made through a lawyer. The court would then give a public notice in the newspaper inviting claims and opposition that this is the person and this person claims to be the class 1 heir. If anyone else has any objection, please come forth. If nobody comes forth, then the court would grant a letter of administration to the legal heirs of the person. This can be used for succession and could be used for various mutation of records, for transferring the 712 extract, and for everything else in favor of the legal heirs. HUF, Hindu undivided family, very popular both in tax and non-tax world. In income tax, earlier we used to have a lot of planning through HUF, and therefore HUFs have got a bad name in tax parlance, but they are even very popular amongst Hindus. What does it mean? Consists of lineal male descendants, that is people, sons, grandsons coming from a common ancestor, and the wives of the lineal male descendants. Since the last 15 years, even daughters are included, and we look at that amendment. Some myths. Now, HUF has a lot of myths. A son is not a must for an HUF. This is a Supreme Court decision in Kauli Budhana. A male, his wife and daughter also create an HUF, Narendranath versus CWT. In fact, an HUF is created when a person marries, that is a male marries, his husband and wife create an HUF. In spite of this, we have our banking system, which seems to follow a different law altogether. Try opening a bank account when a person does not have a son and they say you cannot have an HUF because our legal department says daughters are not eligible and you will not be allowed to form an HUF. Some banks insist upon having a deed. Where is your HUF deed? Just as you have a memorandum and articles for a company or a partnership deed for a partnership or an LLP agreement for an LLP, they ask for an HUF deed. HUF is not by contract. It is a creation of law. It is a creature of law which arises by virtue of a relationship. The moment a Hindu marries and there is some property coming into his family, an HUF is said to have been created. For the purposes of the banks, many times I suggest have a gift deed which mentions that an HUF is being created, and that should suffice for the purposes of opening a bank account. Daughters' rights. Hindu law was very unfairly biased in favor of males, and it yet is. But the Law Commission of India has made several representations to the government of India time and again that you need to set right the unfairness. Therefore, in 2005, 99/2005, the government decided to amend the Central Act, that is Hindu Succession Act of 1956, and provided that daughters will also be co-partners on equal footing with sons. So earlier, only a son of a Hindu Karta could become a co-partner in the HUF. Daughters could not become co-partners. Now it provides that a daughter can also become a co-partner by birth in her father's HUF and in her own right equivalent to a son, have the same right in father's HUF as a son, be subject to the same liabilities in respect of HUF property, and have a share equal to a son. Now all this, mind you, is only in her father's HUF. She cannot on her own start an HUF. So I, as Anup Shah, can have an Anup Shah HUF, but my wife cannot have an HUF in her name because the law yet only permits Hindu males to have an HUF. It allows Hindu females to be co-partner in their father's HUF. What is the meaning of co-partner? Co-partner is the one who can ask for partition of the HUF. Anybody who cannot ask for partition of the HUF is treated as an ordinary member. Now, they amended the law and they said the daughter would have a share in HUF property as if she was a co-partner and a son. But it did not say it applied to which daughters. And there was all helter-skelter bro clause. Each High Court came up with its own verdict. Would it apply to daughters born after 9 September 2005, which is the date of the amendment? Did it apply to daughters married after this date? Or did it apply to all daughters married or unmarried but living on this date? Secondly, was the act prospective or retrospective? There was no clarity at all. Ultimately, 3 years ago, the Supreme Court took cognizance of the matter and in Prakash versus Fulvanti gave a very interesting judgment. It said, A, the Amendment Act of 2005 is prospective, but it applies only to those combination of father and daughter who are alive on 9/9/2005, irrespective of whether the daughter is married or unmarried. So, two conditions. Father should be alive, that is the father whose HUF we are talking about should be alive on 9/9/2005, and his daughter should also be alive on 9/9/2005. If the father has unfortunately died prior to this date, the daughter would not be a co-partner in her father's HUF. So they came out with a McDonald combo offer where both father-daughter combo should be present. Otherwise, daughter does not get a share in father's HUF. Even applies to daughters born prior to the 1956 Act, that is prior to Hindu Succession Act coming into force, not a problem. But her father and she should have been on this date. So these are two important Supreme Court decisions, Prakash versus Fulvanti and Danamma versus Amar, which have laid down this law. So at least now we have clarity on how the act applies and to whom it applies. Coming to the next question, Hindu law always has a Karta in an HUF. Karta is the Karta Dharta. So just as you have a managing director in a company, you have a designated partner in an LLP, you have a Karta in an HUF. He is the person who puts the HUF in motion. He takes decisions, he acts on behalf of the HUF, he does all the duties and functions on behalf of the HUF. Now, question always has been, can a daughter be a Karta? Supreme Court says in Seth Govindram Sugar Mills, a co-partnery is a must for Kartaship. That is, you must be a co-partner. Daughter was never a co-partner prior to 2005. Hence, she could never be a Karta in her father's HUF or in her husband's HUF. Now, a daughter is a Karta in her father's HUF. Therefore, can she be a co-partner and a Karta in her father's HUF? Answer is yes. And that's the Delhi High Court decision in Sujata Sharma. Now, which child would be the Karta in a case when there are several siblings? The eldest. So, if a Hindu daughter is the eldest child in her father's HUF, she will be the Karta, and that was the decision in Sujata Sharma versus Manu Gupta. I told you in the beginning that Hindu law is very biased towards females, and it has been rectified to a certain extent, but not fully. A lady can be a co-partner in her father's HUF, but she yet cannot be a co-partner in her husband's HUF. Here she is yet an ordinary member. It's very, I would say, difficult to fathom that the family which she left many years ago after marriage, she can yet be a co-partner, she can yet be a Karta, but the family where she is today, where she is living, she cannot be a co-partner, she cannot be a Karta in her husband's HUF, because here she is just an ordinary member. So, wife cannot be Karta in husband's HUF. Now, let's look at problems which may arise. What if there is a family of three? Father, mother, and a minor son. Father dies, so there is no Karta. Mother cannot be a Karta because she is a member. Son is a minor, so he cannot be Karta. So in such an eventuality, who will run the HUF? Here Supreme Court comes out with a idea in Shreya. She can be a manager, but she cannot be a Karta. So she would be a guardian manager till such time as her son turns 18. After that, he will take over and be Karta. So in cases where there is no one to be the Karta, the wife can be a guardian manager. In all other cases, it would be the husband, after him the son or daughter, depending on whoever is elder. HUF, as the name suggests, is Hindu undivided family. The family is joined, but we have partitions. And this is something which has been going on since the time of Mahabharata, where we've had brothers fighting with brother over property, and Hindu HUF partitions are very common. What does it mean? It means defining of the shares of co-partners in joint property. So you divide the joint family by a definite and an unequivocal indication to separate. Is actual physical division a must? That is, must I give asset A to one and asset B to the second? Answer is no. That's only a formality. As long as the intent is very clear, this is only a process as laid down by the Supreme Court in Kalyani versus Narayanan. So you need to have a clear-cut indication that you want to separate. Now, it's very interesting to look at a difference between income tax and Hindu law. Hindu law recognizes total and partial partition, whereas income tax only recognizes total partition. Now, what is the meaning of total and partial? So, say there are 7 members in an HUF. The Karta may decide to partition out only one of them. That is, one person goes out, the other 6 continue as part of HUF. That is fine in Hindu law. Income tax will say, I don't recognize this partition. I will yet treat it as if all 7 of you all are together. Or there are 15 properties in an HUF, and the HUF decides to partition out 5 and continue with 10. Income tax will say, no, even the 5 which have gone out, I will continue to tax as if they are part of the HUF, and I will not recognize the partition. Hindu law is over and above HUF, over and above income tax. It is not concerned with income tax. It says, I'm fine. I will consider your partial partition also. So if income taxes are not an issue, you can consider partial partition as respect to members, as respect to property, or as respect to both. But tax is often an issue in this country. So I would suggest do not ignore it and get proper advice on it. How do you partition an HUF? 4 alternatives. Orally, that is, the members come together and decide to partition it. By a suit. If it is a case of a dispute, you can go to the High Court or a city civil court and file a case for partitioning the HUF. By an agreement. So the members decide to come together and partition. This is known as a deed of partition. Or they appoint an arbitrator, a common family friend, a retired judge, who may then give an arbitration award. Now, unless otherwise agreed, HUF partition is always equal. That is, if there are 4 members, everybody would get a 25% share each. If there are 5 co-partners, they would get 20. However, if the members agree, you can have unequal partition where the Karta or any other member may end up getting 99% and the rest may be contented to share 1%. But that has to be only by agreement or by an arbitration award. You cannot have it that I'll do it on my own. So all people need to come together for that. Who can demand a partition? Very important. Only a co-partner can demand a partition. Now, this is where the distinction between co-partner and member comes into play. Can a wife demand a partition? Is a wife a co-partner or a member of her husband's HUF? Very clearly, she's only a member. Therefore, she cannot claim partition during her husband's lifetime. Even after the 9th September 2005 amendment, any changes qua wife's position? No. But how much share would she be allotted on partition? She would be allotted a share equal to that which her son or daughter got. So if there are 4 people in an HUF, father, son, daughter, and wife, wife cannot claim partition, but if the son gets a 20% stake, she also is entitled to a 20% stake. If son gets 25, she also is entitled to 25. Interestingly, while a wife cannot claim partition of her husband's HUF when the husband is alive, there is a judicial controversy over whether a widow can claim partition of her deceased husband's HUF. And the overwhelming view seems to be yes, that a widow can claim partition of her deceased husband's HUF because now her husband is no longer there and she needs to take care of herself, and therefore she can rely on the joint property to sustain and maintain herself. So very difficult to fathom that in husband's lifetime she cannot, but after his lifetime she can. Can daughter claim partition of father's HUF? Yes, Hindu Succession Act places her on same footing, and therefore all rights which a son enjoys, she can claim partition. Now here some unanswered questions in the Hindu Succession Act. It says that the daughter enjoys same rights as the son. Now the son's children automatically become co-partner in their paternal grandfather's HUF. Would the daughter's children also become co-partner in their maternal grandfather's HUF? I think yes, because if you are on the same footing as a son, why should you distinguish? The son's children, the eldest of them, would become the Karta of their grandfather's HUF after their father passes away. Similarly, can the daughter's child become Karta in the maternal grandfather's HUF if he is the eldest or if she is the eldest? I would think yes, because if son and daughter are equal, then Karta has to be one of the cousins who is the eldest. However, these are unanswered questions and uncharted territory. So we'll have to see whether we have to again go through court cases for that. Income tax is neutral on partition, provided it is total partition. So there is no tax levied when there is a partition. However, it is not stamp duty neutral. The Maharashtra Stamp Act in the state of Maharashtra and also the Indian Stamp Act in other states levies 2% stamp duty on the fair market value of the separated share of property. The separated share of property has been defined in a very verbose manner. It is the largest share remaining after partition from which other shares are separated. What it means has not been explained, and therefore it is open to interpretation. But what it correctly means, if there are 4 members and 3/4 share in the HUF on partition, that is 75% went to the father and 25% was divided amongst the other 3 members, then stamp duty is leviable on 25%, that is 2% of 25%, not 2% of 75%. If all are equal, subtract any one share and pay stamp duty on balance. Now, practically what happens when you go to register a partition deed concerning an immovable property, if that is if the HUF has immovable property and you want to partition it, and you go to register this partition deed, the registrar always insists stamp duty on the largest share, whereas correctly it should be on the smallest share. To put my example into better theory, if there is a 99% and 1% split, 99% goes to 1%, 1% is divided amongst the other 3, stamp duty would only be on the 1%. However, the registrar and the collector insist on stamp duty on 2% on the 99%. That's a totally erroneous stand to be taking, but there is often a slip between the cup and the lip. So practical reality is devoid from the correct reality. So this is something which you would need to correctly bring out to the notice of the registrar, that stamp duty is only on the smallest share, not the largest share. Ancestral property. One more area of confusion when it comes to HUF. Any property inherited from 3 generations above of a male lineage, that is father, grandfather, great-grandfather, is treated as ancestral in the hands of son, grandson, and great-grandson of a Hindu, and all have an automatic right in ancestral property. It is deemed to be joint property. So what it is saying that if you have anybody which came from 3 generations of any of your 3 generations above, that is from your father, grandfather, or great-grandfather, then for 3 generations below it will be ancestral, and they will be treated as if the property is HUF property, even if it is received in your personal name. The commonly understood view is that ancestral property cannot be alienated. That is, a person cannot gift, will ancestral property. It continues to be joint and it continues within the family. Passes only by law to son and grandson. However, this is the common view. The correct view is ancestral property can be alienated. There's a lot of judicial and otherwise controversy over this. However, Section 8 of the Hindu Succession Act is very clearly said that it has modified all old Hindu customs and traditions. And various Supreme Court decisions have said that ancestral property devolving on a person would become a self-owned property. Once joint property has been distributed, it ceases to be joint and it becomes solely held. Therefore, It is not ancestral, but it is to be treated as self-acquired, and the Hindu person receiving it can gift or will it away. So this is the correct decision on the point. However, a lot of newspaper reports, a lot of decisions are taking a incorrect view on the matter. Recently, there were two Supreme Court decisions, both rendered within a gap of 1 day. One said ancestral property can be alienated only if it is received prior to 1956, that is before the Hindu Succession Act came into force, which is the correct view. After that, it would be self-acquired property. The second said ancestral property continues to be joint and it cannot be alienated. This second decision has ignored all Supreme Court decisions on the point, and it has just given a decision on its own. I submit that the earlier decisions are correct. That is, there is no longer a concept of ancestral property. It continues to be sole property and you can gift or will it away. HUFs, in my view, have now become weapons of mass destruction, and they should meet its natural death, that is, they should be partitioned. In fact, the recent Law Commission report also suggests so. What are the reasons? Ownership of property in an HUF is very risky. Multiple owners end up owning the same property. If you want to sell it, any buyer is wary of buying such property. Whether I have got concurrence of all the people, would there be a lawsuit from some co-partner tomorrow? What about unborn children? There are so many open issues when it comes to an HUF that I would suggest it's not worth putting valuable property in an HUF. Secondly, US tax has totally driven HUFs up the wall. If one or more members, whether Karta or co-partner or member, is a US citizen or a green card holder, how to show it in American tax is a big issue. Who files the FBAR, that is the foreign bank account report? Should the HUF file, should the Karta file, or should each member file? All these are open issues and there's no clarity on that. And thirdly, the stamp duty issues on partition. All this put together, in my view, shows that HUFs should be partitioned and property should be owned in individual hands only. The most common question which I have seen in my several years of estate planning practice, I have two children who will inherit everything after me. Everything will be held jointly with them. Why should I make a will? That's the common question or excuse which I have heard. Now, do note, as we'll see, joint owners are only stopgap owners. Ultimately, the property will pass as per the succession law. If there is no will, in case of Hindus, all class 1 heirs would end up owning shares in all assets. So you have two children. Each of them will have an equal share in every asset. So there would be cross ownership across the assets. That is, son 1 will own in flat A and B, son 2 will own in flat A and B. If they want to separate and segregate, there would be tax and stamp duty issues which could be very expensive. Plus, there would be legal costs. What if they can't amicably resolve ownership issues? There would be court battles and there would be bad blood. Do you want to leave behind a legacy of problems for your children? I'm sure the answer is no. Therefore, plan you must. The thrust and the title of my talk today, that planning is a must. Do not think I have two children or two sons and I have equal ownership. That will be looking at a very foolhardy approach to planning. Cross ownership is often the biggest problem when it comes to estate planning. Let us now look at estate planning options. So you have a pyramid approach. Joint holding and nomination, which is the most rudimentary planning which should be done. Then you come to wills, and ultimately most sophisticated are trusts. Trust could be done on death or lifetime, whereas the other two are only on death. Let's first look at joint holder or nomination. Now, joint holder is a concept which is very common for flats, bank accounts, fixed deposits, demat accounts, mutual funds, physical shares, and public provident funds. How can the joint holder be? He can be either or survivor or former or survivor. What is the difference between the two categories? Either or means he can transact along with the first holder in a bank account or in any other account. But in the former or, he can transact only after the first holder dies. In both the cases, the survivor, that is the second holder, becomes the owner on the death of the first holder. Nothing needs to be done. Only a death certificate needs to be produced, and automatically the second holder becomes the sole holder. Very important to note, joint holder is not the beneficial owner. Ownership continues to remain with beneficiaries under the will or as per the Hindu Succession Act or any other legal heirs succession act. This is only a stopgap arrangement. Second, we come to nomination. Very popular, but full of misunderstanding. If there is one concept in succession planning which is very well understood, but at the same time very misunderstood, it is nomination, which wins hands down. And I'll show you why. Nominee is only entitled to receive the assets on death of a person. So law does not like vacuum when it comes to ownership of property. It says, I want a face to deal with. Person has died. Immediately on the date of his death, I want somebody to whom I can ask questions. Are you the owner? That is the nominee. So nominee is a stopgap arrangement from the date the person dies till the time his estate is executed and beneficiaries are made owners. It plugs the gap between death and bequest to beneficiary, puts the nominee in the deceased shoes, but very important, and I'll put it in bold when I'm talking, by no stretch of imagination makes him the absolute owner of the asset. It is only a stopgap arrangement. What prevails? Wills or nomination? Nomination or legal intestate succession? Always wills, intestate succession prevail over nomination. Nomination is at a much junior hierarchy when it comes to wills or succession. Once a will is properly executed, nomination automatically ends. In the case of bank fixed deposits, the Supreme Court in Ramesh Talwar has given a view that the nominee is subservient to the will and the will prevail over the nominee. In insurance policy, we have Uma Devi Supreme Court decision where the Supreme Court has again said will prevails over nominee. In national savings certificates, in public provident funds, in employee provident funds, everywhere the Supreme Court has time and again said will prevails over nomination or intestate succession prevails over nomination. Nomination is only a stopgap arrangement. In spite of that, in spite of numerous Supreme Court decisions, there have been every time a nomination, the bank, the insurance company will start asking questions whether it should be the will or the legal owner or the nominee who should get the asset. Immediately on death, it's the nominee. Till the time the will is proved or executed, it becomes then the person under the will. Nomination case of this, the University of WhatsApp has created mass confusion. I love to read University of WhatsApp decisions because they are totally incoherent and totally devoid of reality. Now here the Supreme Court gave a very interesting decision in the case of Indrani Wahi. This was in the case of the Kolkata Cooperative Society Act because it was a cooperative society flat in Kolkata. There were 3 people living in a flat, a father, mother, and son. Daughter was married and living with her husband. Father decided to nominate his daughter, his married daughter, in the flat, and he filed the nomination papers with the society. He died, and after him, the married daughter went to the society and gave the nomination and said, look here, I am the nominee. Please transfer my father's flat in my name legally. The mother and the son said, how can he make her a nominee when he was living with us? When he was sick, we took care of him. How can he make her the nominee? So the society chairman agreed with them and said, yes, I will not transfer the nomination in her favor. She went to the Cooperative Society Tribunal, which also upheld the view of the chairman. She again went to the Kolkata High Court, which also upheld the view of the chairman. Ultimately, she went to the Supreme Court, which said nothing doing. Nominee is entitled to possession of the flat. Nomination, if validly made, is binding on the cooperative society. The society has no option but to accept the nomination. Society cannot question why daughter was nominated over mother and son. That is not the society's prerogative. Society only has to see, has the nomination form been correctly filled in? Is there a proper signature? If yes, that's all. And you have to transfer the flat in favor of the nomination. Secondly, the Supreme Court rightly said nomination has no relevance to the issue of title between the successors to the property. That will be decided whether there is a will in this case, whether he died without a will, all that will be part of the succession law. And that ultimately she will have to give it over to the person who becomes the beneficial owner under the will or under the Hindu Succession Act. But right now, nomination transfers the legal husk of the title in her favor. Hence, if you are a member of a managing committee of a society, please do not get into succession issues. Please do not look at whether the will is appropriate. Only consider whether the nomination is correct, and after that, transfer the property in the name of the nominee. In Maharashtra, thankfully, last year we had an amendment to the Maharashtra Cooperative Societies Act. A concept of a provisional member was introduced. So, a provisional member is a member in favor of whom nomination is made, and on the death of a member, he is temporarily admitted to the membership of the society as a provisional member. And the law very clearly mentions this is a stopgap arrangement between the date of death and the date of execution of the estate of the deceased. So now the Supreme Court judgment in the state of Maharashtra provides that nomination is only a stopgap arrangement. In the case of company, again, there's a controversy. Now, the Companies Act came with a very funny kind of an legislation which says shares vest in the nominee, overriding any other law or will made by the deceased. And therefore, nominee becomes the owner. Similar amendment was made to the DMAT Act to provide that in case of nomination with DP account, the shares vest in the nominee overriding any law or will. So then, hence in the case of physical plus dematerialized shares, the question arises, who prevails, nominee or will? The Bombay High Court single judge gave a view that based on the wordings of the amendment, nominee prevails over the will, reverse than what I have been talking so far. And in this case, a husband and wife were living together and they had no child. The husband made a nomination in favor of his nephew. The Bombay High Court upheld the nomination in favor of the nephew and said he will become the legal and beneficial owner, and the will in favor of the wife will not survive because it is contrary to nomination. This created a lot of chaos because this means that all nominees would start owning up shares in case of a will. So who prevails? Again, Bombay High Court in another case, a single judge said no, the earlier decision is wrong. It has not considered the Supreme Court cases in other asset classes, and therefore nominee will not prevail over will in case of DMAT or physical share. Will prevail over nominee, and nomination is not a super will which will alter the succession pattern. This view has been upheld by a two-member Bombay High Court decision, and therefore now the law is that will prevail over nomination even in case of DMAT shares, that is a DP account, or in the case of physical shares and debentures. Very thankful relief brought forward by the Bombay High Court decision, because otherwise there was a lot of uncertainty and ambiguity. Now, we spoke about joint holder, we spoke about nominee. Who to decide, should I make a joint holder or should I make a nominee? What is the hierarchy? First joint holder, last nominee. If you are 100% sure that wealth should go to a certain person, make him a joint holder. This happens in the case of husband-wife. So spouses should be joint holders in each other's accounts, because after the death of a husband, he would want the wife becomes joint holder, and after the death of a wife, automatically husband would become joint holder. Nominee would get it only after both the joint holders pass away. So they can make their children nominees, and spouses can be joint holders. But ultimately, very important, both should be in sync with the will. Otherwise, you have a problem. I have seen umpteen wills where nomination in favor of son, will provides it goes to daughter. You are sowing the seeds of descent between your son and daughter. Nomination in the favor of brother, will provides will go to the son. You are sowing the seeds of descent between the two. If you change your nomination, change your will. If you change your will, change your nomination. Ensure that you do a spring cleaning every periodic basis to ensure that nomination and will and joint holder all are in sync, so that there is no ambiguity. Nomination can be changed as many times as desired. If after making a nomination, relationship dynamics have changed, change the nomination. There are several times when a person makes a nomination in favor of his brother. and then relation SARS, but he forgets to alter the nomination. Even after his death, the brother will become the legal owner and his children and all will become the rightful owners only after the will is probated. For some assets such as mutual funds, you can have split nominations. That is, you can have 40, 30, 20 or 25, 25, 25. But for some assets, you may not be able to do that. You will decide on the asset class. You need a witness for making a nomination. A minor can also be a nominee. Better, or I would say imperative, that a will and nomination are to the same person. Otherwise, there would be chaos. So nomination is a stopgap till a will is executed, provides for immediate transmission of the asset, and can be for flats, shares, FD, mutual funds, insurance, DP, and is a must. So nomination is the most basic form of estate planning which you can do. Let's now come to wills. What is a will? A will, it's will. Is a wish, a desire of a person as regards to disposition of his property after his death. How should he dispose of his property after he dies? It is a legal declaration of a testator's intent. So testator means the person who is making the will. And here our Bollywood movies have fed us a very rich diet of misinterpretation and confusion, which we look at. It is not valid till the testator dies. That is, it speaks from the grave. Very dramatic sentence to be making, but it is only valid when a person dies. So when you have in Hindi movies a gun pointed at somebody's head saying, sign on this will, it's no matter. He could sign it as long as the bullet is not fired. He doesn't have to worry. He can go home and change the will. Nothing turns on it. Can be revoked n number of times by the testator in his lifetime. So I take away one tomorrow morning and third tomorrow evening. Which will prevail? The last will. So you can keep making wills as many times as you want. It gives you complete discretion on distribution of property after death to persons of your choice, reduces succession dispute. It's a good way to reward someone by willing away a part of wealth post a person's death. So if a person, there's a husband and wife, but the husband wants to give away everything to charity, his wife is self-sufficient in her own respect, he can do so by virtue of a will. If he does not make a will, everything will go to his wife by virtue of the succession law. Better to make a will at an early age due to uncertainty of life. And this is something which I don't need to explain looking at the environment which we are living in today. Because of the uncertainty which is there in the atmosphere, better make a will at an early age. I would say any adult owning property is eligible to make a will and should make a will, because there are no limits on the number of revisions to a will. At least have a basic draft ready. That's good enough. You can always improvise it further. Who can make? Any major person of sound mind. I should be able to understand and know what I'm doing and signing. If the person is intoxicated, substance abuse, drugs, or alcohol, and or he does not understand what he is doing, he cannot make a will. Can a deaf, dumb, or a blind person make a will? Answer is yes, provided he knows what he is doing and signing. So if it is in braille or if it has been explained to him, yes. A person who is ordinarily insane, he can make a will, provided it is during his sanity intervals. That is, when he made the will, he was sane. The biggest question would be, how would you demonstrate that at that point of time he was sane? Here, in such cases where mental faculties are in doubt, it is very, very imperative that a neurophysician or a psychiatrist certificate as to mental fitness is attached to the will. Can an illiterate person make a will? Definitely. But he must know what he is putting his thumb impression for. Very old and feeble persons can make, but they must again be able to communicate their wishes clearly. Person who is terminally ill, cancer patients on deathbeds in hospitals often have made wills. Again, very important, how were they able to communicate their wishes? Lunatics cannot make a will. A person with Alzheimer's disease. Now, this is something, Alzheimer's and Parkinson's. Alzheimer is a mental disease where it is very difficult for the person to understand what he's doing. Therefore, such a person, it would be difficult for him to make a will. Can a person with Parkinson's disease make a will? That is, he has motor disability over his motor functions. Even though a neurological disability, he can make a will because he yet knows what he's doing. we had an interesting question. Can a mentally challenged person make a will if he or she is the owner of certain property? Answer is clearly no, because he or she does not know what he is doing. How would she make a will, or how would he make a will? In UK, they have the national guardianship law where they say that the natural guardian of the mentally challenged person can make a will on his or her behalf. We don't have any such law in India, and therefore any property owned by such a person would pass by intestate succession. So if such mentally challenged person is a Hindu, then the Hindu Succession Act would apply. Very important, therefore, not to gift any property to such people directly. If you want to, make a trust for their benefit. We'll look at how you can make a trust when we come to the trust angle. How do you make a will? Again, Hindi movies have taught us you need a stamp paper. No, you do not need a stamp paper. Some of the most important wills in America have been made on the back of a tissue paper sitting in the cafe of a restaurant, or a cafe. You can do it on the back of an envelope. It could be in handwritten will. It should be legible and clear. Signature or thumb mark of the person making the will is required, and two witnesses are required who have seen the testator sign in their presence. You need to appoint an executor, that is a person who would put the will into motion. Very important to date the will, because the last will prevails. So if you don't know whether it is the last or second last, how would it prevail? Designate the legatees, that is the person who get the benefits under the will. And I prefer to make it as detailed as possible. I could make a one-liner saying I leave everything to my wife, but I prefer to enumerate the assets which are with me today and then leave a residuary clause for the assets which I will acquire hereafter. Let's now understand this in detail. Who can be a beneficiary under the will? Most important person, the person who gets the fruits of the estate. He gets what is there under the will. Who could it be? Any family member, friend, employee, servant? Can a CA or a lawyer be a beneficiary under a will? Definitely. It can even be a stranger. So even I could be a beneficiary under your will. And at the end of this presentation, I am giving my contact details. Please feel free to make me a beneficiary under your will if you want to. And I would be more than happy to be a beneficiary under your will. Can pets be made a legatee under a will? Karl Lagerfeld, the famous designer, his cat would inherit US $380 million or 2,700 crores at that time. He set up a pets trust. So I would always say set up a pets trust in which the trust would be for the benefit of the pets. I know of a Mumbai couple who have created a trust for their two golden retriever dogs, leaving behind 5 crores for them. Because if you put the money directly under the will for the pet, for the dog or the cat, then he or she would not be able to open a bank account, a demat account, because till now we cannot open bank account. We won't get Aadhaar for the dog. Then how will you get a PAN? How will you get Aadhaar bank account? Therefore, please have a trust for the pets and use that if you want to leave anything for the benefit of the pets. Can you ignore a close family member under a will? Definitely. There are cases where people say, I don't want to leave anything to my son or daughter or any such person. That is also possible, and you can leave everything to a servant also. Who is the executor? He is the person who puts the will into action. It does not mean the person who kills someone. He's not executing. He's executing the will into process. Who must he be? Someone close to the testator, because otherwise he will not agree to be an executor. Better to check with the person whether he wants to be executor and he's willing to be. Advisable that he's younger to the testator, because otherwise you'll have a problem that before the testator, the executor has passed away. What are his duties? Provide for all the funeral expenses of the testator, pay off any liabilities which the testator owns, if not appointed. So supposing you made a will but not appointed an executor, or the executor has predeceased the person making the will, then what happens? Then court would appoint an administrator for the will who would become the executor. So always better to have multiple alternative executors. So if one is not there, second comes into force, second is not there, third comes into force. You can also have joint executors where two or more people jointly would execute the will. Witness to the will, most important. Two or more witnesses are required who must see the testator sign or put his thumb impression in their presence. So they must see the testator sign the will in their presence. They need not know the contents of the will. Very often I'm asked a question by my clients. I don't want X or Y to know what's in my will, but how do I make him a witness? He need not see the witness, the contents of the will. He will only see the person sign in their presence. Who should it be? Can be any friend, any family member, any relative, any lawyer, chartered accountant, doctor. Can witness also be beneficiary under the will? Answer is yes and no. Indian Succession Act says the witness cannot be a beneficiary. But if the person making the will is a Hindu, then witness can be a beneficiary. Is it advisable? I prefer to have separate roles, separate horses for courses. Witness and beneficiary should be separate. Can witness also be an executor under the will? Yes. Here the law expressly provides that witness can be an executor. If testamentary capacity is doubtful, that is, if the person making the will is very old. So I had a person who was 94 years. Obviously, questions would have been raised. Was he mentally sound? So we got an evaluation done by a neurophysician of one of Mumbai's best hospitals and attached his certificate to the will and kept a record of this in the hospital's database. So that would show that yes, he was mentally alert when he was making the will. Top 10 myths busted when it comes to preparing a will. Will must be on a stamp paper or a ledger paper. No, it can be handwritten on a plain paper, but must be legible. There is no legal format for making a will. Will once made cannot be changed or altered. That happens only in the movies. You can n number of times alter it. Will is effective during a person's lifetime, only happens in the movies. Wills can take effect only from the grave. Will cannot exclude near relatives. You can bequeath everything to charity, servants, friends, excluding spouses, kids, etc. Will must be dated because last prevailing will prevails. Nomination prevails over will. No, it's always the reverse. Married woman cannot make wills. Married woman can make wills. No witnesses are required. Witnesses are required and you need 2 witnesses. The last one is very important. Marriage revokes a will. So the moment a person marries, if he has made a will prior to marriage, it gets revoked. And if he doesn't make a new will, it is treated as if he will die intestate. Answer is yes. But this is not so in the case of wills made by Hindus. So in case of Hindus, wills made prior to marriage need not be remade and the earlier will prevail. Special issues. If there is a physically, visually, or mentally challenged person, he is an autistic or a schizophrenic, mention the exact nature of disability of such beneficiary, provide for a guardian or a caretaker for such a child or relative, and ideally have a trust under the will for such a relative, which will take care of their needs. What if you want to make a life interest beneficiary? Now, this is very popular. Say there is a husband and a wife, and there is a child after that. The husband provides in his will that after me, my son or daughter would be the owner of the house, but my wife would be a life interest beneficiary. That is, she cannot sell, she cannot will, she cannot gift the house, but she can reside in it till she is alive. Till the wife is alive, the child cannot sell the house, cannot gift it away, cannot do anything. So the wife continues to remain the residing person, but the son or the daughter immediately becomes the legal owner once the will is executed, subject to the life interest beneficiary. Now, joint wills and mutual wills. These are questions which I often get when I give talks on estate planning. Should I make a joint will? Should I make a mutual will? Let's understand what they mean. Wills made by 2 persons, husband and wife. Couple prepares one will saying after husband it goes to wife, after wife it goes to husband. And if both are not there, they also lay down the distribution of property. This is known as a joint will. What is a mutual will? This is a mutual agreement between 2 or more people based on which they have agreed to make their will. So by a mutual will, husband gives everything to his wife. By a mutual will, under her will, wife gives everything to husband. But they also provide that if any of them were to predecease, the wife's brother would get the property. Now, wife dies first and husband decides to change his will, leaving everything to his niece rather than to his brother-in-law. The mutual will which he had made with his wife would prevent him from doing so because he had agreed upon a contract with his wife who was then living, which can be altered only if both of them are alive. Today, the wife is no longer alive, and therefore he cannot go back on his words. So, if you have made a understanding, only two of you can change it. You cannot now renegotiate and renege on your contract because one of the parties has died and now the mutual will prevent you from doing so. So you need a lot of specific language in the will to show that it is a mutual will. Otherwise, courts do not give cognizance to mutual will. I generally don't prefer joint wills or mutual wills. I prefer separate wills for couples because estate planning for a couple could have separate issues for each partner. There could be issues such as divorce, remarriage, etc. Different interests could be there. One may want to bequeath everything to the family members, some may want to give everything to charity. Lastly, wills require obtaining probate, and it could become a complicated affair when there are mutual wills and joint wills. Therefore, have a separate will for each partner in a couple. Even if there are mirror wills, that's okay. That is, one is a reflection of the other. That is fine, but don't go in for joint or mutual wills. One situation where a mutual will is advisable for a couple, if the intent is to bind a couple to a certain disposition pattern without giving a chance to wriggle out after the demise of one of the pattern. What does it mean? There's a fear of remarriage. Husband fears that after he dies, his wife will remarry, and there could be new claimants to the joint property of the couple, which could alter the pattern. So if the wife remarries, then her new husband, children from that marriage, he does not want them to be beneficiaries under the property which they currently have. So now they enter into a mutual will saying husband gives everything to wife, wife gives everything to husband. If neither of them are there, it goes to certain relatives. None of the surviving partners can now alter this mutual will because reciprocal promises have been made, which could have been altered only when both were alive. Now, one of the parties has passed away. Therefore, you cannot alter this mutual will. So this is a situation where a mutual will is advisable. So you need to take a very clear-cut approach when to go in for mutual will, when to go in for mirror will or a joint will. If there are foreign properties, consider having a separate will for each country with cross linkages in all wills. So in the Indian will mention this is only Kwama Indian property. In the Dubai will say it is only Kwama Dubai property, but do mention cross linkages that I also have an Indian will for my Indian properties. Assets in UAE, consider a DIFC registered will or an Abu Dhabi global market registered will. For American assets, pay heed to US federal and state estate duty, which can be as high as 50%. Secondly, probate fees can be very high in America and they vary from state to state. California levies the highest probate fees. UK has a 35% inheritance tax. So whenever you have foreign assets, do consider cross-border estate duty and cross-border estate planning issues. Tenanted premises. Very popular question, especially in Mumbai, where we have tenanted and pagari premises. Supreme Court has said that if State Rent Control Act prohibit, tenanted premises cannot be willed away. The Maharashtra Rent Control Act of 1999 provides that in Mumbai and in Maharashtra, you cannot make a will for tenanted property. In such cases, the Rent Act takes over. So it first goes to the family members of the deceased tenant who are residing with him at the time of death in case of residential property or working with him in the case of commercial property. So if it is a residential property, family members of the deceased tenant will get it. If it is a commercial property, family members who are working with him will get it. What does family mean? No definition. It's generally understood as those connected by blood relationship or marriage, married, unmarried, widowed, daughters, etc. Bombay High Court had an interesting case that an entire HUF cannot be a family member of a tenant. So in one case, a person died and he said that his HUF came forward and said, all of us will become tenants. The answer was no, only individual family members would become tenants. If there are no family members, then legal heirs of the deceased tenant would succeed. What do you mean by legal heirs? Those who are legal heirs as per the Intestate Succession Law, that is the Hindu Succession Act or the Indian Succession Act. Supreme Court has said brother of a married lady is not a legal heir for property which devolved on her from her father-in-law. Now, if the State Rent Control Act does not have a prohibition Can you make a will for tenanted premises? Answer is yes. Hence, for every state, you need to take a call. In Maharashtra, you cannot do so. And most states have rent control acts which provide that you cannot make a will for tenanted premises. You can mention that you are a tenant of your tenanted premises, but you cannot will it away in your will. Registration of will. You can register your will with the sub-registrar. It is not compulsory or mandatory to require a will. Why is it advisable? When you want to prevent against forgery or undue influence or question mark of mental capacity, the moment you go to the registrar, there is a government authority which is seeing you sign the will in his presence. Therefore, all questions of forgery are no longer entertainable, because now it is very clear government has seen you sign the will. It is a genuine will. However, a registered will can be superseded by a subsequent unregistered will. That is, say you went to the registrar and you signed in his presence. You came home and you decided, no, I want to change my will. Now I make an unregistered will. That will prevail over the registered will. You can also consider notarization before a notary public. Registration is not required even if the will contains only immovable property. Registration could be with any registrar where the person is living in that area. Probate. It's a copy of a will certified by a court seal. Since will takes effect when a person dies, how do you know whether the will is genuine or no? Therefore, the executor will apply to a court of law, and once probate is granted, that is, the certificate is granted, no claim about genuineness of the will can be made. How do you apply for a probate? You make an application. So in the state of Maharashtra, you make it to the Bombay High Court. You pay court fees. As per the Bombay Court Fees Act, it is 3% of the estate value, but maximum is 75,000 rupees. So irrespective of the upper limit of the estate, the upper limit of the court fees is only 75,000. You give details of the legal heirs of the deceased, who is the executor, and who are the witnesses. They need to go in front of the registrar. There is a court registrar or the notary public and sign in front of him. General notice is given to public inviting objections that probate is being sought for the will of Mr. A. If you have any objections, please apply to the court. Give a fair market value of assets of the deceased on the date of death. Once all objections are considered and everything is proper, the court will grant a certificate. Is it compulsory? Answer is yes and no. For any Hindu living in the state of Maharashtra, Calcutta, West Bengal or Tamil Nadu, a probate is compulsory. For any other person who has immovable property in these three states, a probate is compulsory. For any other person not having immovable property in these three states, probate is not compulsory. So if you are a Hindu living in Delhi and you have no property in Maharashtra, Tamil Nadu or West Bengal, you do not need a probate. If you are a person living in Gujarat and you have no property in these three states, you do not need a probate. However, a probate is advisable when there is a dispute. In fact, in such a case, it would become mandatory, because if two people come with conflicting wills, how will you know whose will prevails over the other? So in such a case, a probate is a must, and therefore, if there is a dispute, you do need a probate. Or if the law provides, which I mentioned about these three states, then you do need a probate. New developments. A video will. Here, the testator is videographed, just as currently I am being videographed on Zoom, reading the contents of his entire will. It helps prove that he was mentally competent, and the videotape would also show the witnesses signing in presence of him. Digital will, very important. A lot of our assets today are online. Social media accounts, online bank accounts, digital data, emails. You may want to will away all of that also. Consider having a separate digital will or have it as part of the will in that respect. Some social media sites have separate rules when it comes to bequest of digital assets. You can also consider certain digital bequest sites like safelocker.com, which lay down digital passwords for various accounts. You just need to give password to that one site. It'll give passwords to all the online accounts. Organ donation and social customs. Kidney donation, skin donation, eye donation. If a person wants to do that, do not include it in the will, because in all likelihood, the will would be referred to after the cremation or burial of the person, by which time organ donation would not be possible. Hence, have a separate organ cum social custom will. Social customs are whether to do a full ceremony after a person dies for 13 days, whether to have an elaborate prayer meeting. I have clients who want a very simple ritual. So they lay down a social custom and an organ donation will, which is given separately and explained in advance to the family members that after he or she passes away, this is how he would prefer to have the proceedings in this respect. Putting it all together, describe the testator, age, address, Aadhaar number, passport number, so that it's easy to identify. Define family members. Avoid using only nicknames. I've seen wills where they say, I leave everything to Bittu or Tikku. Now, who is Bittu, Tikku? It's difficult for the court to understand all of this. Please give full names and be very clear. There are cases where at one clause it is said that I give this house to my son, and somewhere down it says I give the house to my daughter. Executors should be joint or could be alternative. Dating is very clearly to be mentioned because it revokes all wills. Give page numbers and para numbers. Describe properties as much as in detail as possible. If you have excluded a close family member, say amount was spent during lifetime on marriage, education, relocation, or make a gift, do mention it in the will. It help cause disputes. I mean, help quell disputes. In terrorum clause, many times I provide for this clause that if any person contests my will, he or she would be disentitled to get anything under the will. This is a valid clause and courts do take cognizance of this clause. So you can provide this clause. Signature must be clear and very easily identifiable. Witnesses we discussed. Should I make an online will or should it be seeking professional help? At the risk of sounding biased, I would say do seek professional help. Online wills cannot look at all pros and cons and all permutation combinations. Every will has certain nuances. Therefore, do seek professional help. Living will. I said will takes effect from the date of death of a person. What is a living will? A living will is made by an adult of a sound and healthy state of mind, voluntarily and without influence or coercion. It is a direction, a medical directive to the doctors as to how he would be like to be treated if he is in a state of coma or not able to take a decision. Here, in various foreign jurisdictions, we have euthanasia. That is, you can ask to be killed if you are suffering from a lot of problems. You are in last stage of cancer, you are in a lot of pain, then you could be given a lethal injection. That is not allowed in India. But the Supreme Court has come out with a modified living will saying that you need to specify two witnesses and a judicial magistrate, that is a court, must countersign your living will. If a person is undergoing treatment, the doctor must give due weightage to the living will. The doctor and the hospital must form a medical board of 3 senior doctors comprising of a cardiologist, a neurologist, and a physician to examine the patient, and they would decide whether to follow the living will. If this is okay, they would give the living will to a collector who would then constitute an independent medical board of 4 doctors. If they permit the living will to be executed, then the judicial magistrate would allow the will to be executed. After so much back and forth, the living will have no significance only. The person will die before that. Because if we are looking at a case whether or not to switch off the ventilator, imagine having a hospital medical board, having a collector's medical board, going to court. It's a long process. So in effect, living wills cannot be given effect in the country of India. Nevertheless, it is advisable to make a living will giving medical directives as to how you would be like to be treated if you are in a state of coma or a vegetative state. You never know when the law may change and when living wills may be accepted. Hence, do consider making a living will also. Lockdown will. That's something which usually I don't cover in my presentations. But in the last 50 odd days, ever since lockdown and COVID has taken over, I've made several wills which are lockdown wills. What are they? Normal will, but what are the important questions which arise? What is the format? This is a question which I've often said. I have no access to a printer. I do not have ledger papers. I do not have stamp papers. How do I make a will? As I mentioned, there is no format for making a will. It can be handwritten on a plain piece of paper also, but do ensure it is legible, because no chicken scrawl handwriting, no doctor's handwriting, which people cannot understand. If you cannot understand the contents of the will, it would be treated as an invalid will. Bigger problem, getting two witnesses. How do I get two witnesses to sign, to see me sign? Neighbors may be requested, but what if they are reluctant to do so due to social distancing issues? Servants, maids, watchmen may be asked to act as witnesses. Either they write their name or they affix their thumb impression. What if there are no servants also because of the lockdown? In such a case, the adult family members of the testator may be approached. So, husband, wife, father, mother, but they can be, if they are beneficiaries, then they can be witness only if they are Hindus. In other cases, that's not possible. So, you need to bear all these issues in mind when looking at a witness. Can witnesses practice social distancing and yet witness the will? That is, somebody standing 6 feet away and yet can he see me sign? Here there are two English decisions, including one of 1781. Our law is based on English law, and hence I'd refer a lot to English law, and one of 2011. The 2011 is quite interesting. There was a witness and there was an executor, and between them there was a glass door. They were in adjacent rooms, and between them there was a glass door. The court said the witness could clearly see the person signing through the glass door, and hence it was treated as a valid witness. Thus, if the witness maintains 6 feet distance and can clearly see the testator signing, that is permissible and would be treated as a valid witness. Some jurisdictions have come out with online witnessing, and they have been pioneers in this. Scotland allows the lawyer to arrange a video link by Zoom or Skype with the client. If this is done, the solicitor can witness the client signing each page, and once lockdown ends, you can physically sign it. Several states in America, such as New Jersey, allow online witnessing and notarization of wills using Skype or Zoom. In Canada, several provinces such as Quebec permit the online notarization of wills. In India, a witness cannot be by Zoom or by Skype or by any other WhatsApp. It has to be physical only. So our Indian Succession Act of 1925 has yet not been amended. It would be a good idea if the lawmakers would permit such online witnessing, because in times like this, it is a must. A doctor's certificate I mentioned is normally required as to the mental fitness in the case of very old people. And it is advisable that he is a neurophysician or a psychiatrist, not just a general doctor. How do I get this under lockdown? Consider if the doctor is being regularly consulted, and if a Zoom could be done so that the doctor can issue the certificate on that basis and keep it with himself, that is with the doctor. The physical certificate may not reach the testator today, but the same could be collected once the lockdown eases and then attached to the will. If that is not possible, then it becomes very difficult to get this certificate in case of a lockdown. A COVID will, which is also known as a hospital bed will. What happens in case of a person who is unfortunate enough to contract the virus and has been placed in a quarantine facility in a hospital? How can he make a will? The issues peculiar which I discussed earlier would apply to him also. But the biggest challenge would be getting two witnesses. Who would sign as witness to such a will? He could request the doctors and nurses treating him to help him out. That is the only way for a patient in isolation ward to make a will. Otherwise, he has to wait till he's out of the quarantine facility. Therefore, plan today, do not wait till tomorrow. It is very important that a will is made ASAP, as soon as possible. Trusts and gifts. Why trust? Useful if the beneficiary is a minor. You don't want to place huge sums of money and wealth in the hands of minors, so you can take care of that. Even useful for people who are mentally and physically challenged. Complete control during the lifetime and after death. No probate required like in case of a will, so you don't need to go to court because everything is done today. It reduces succession disputes like in case of wills, and helps avoid estate duty. Now, of course, I'm making it very loud and clear. We do not have estate duty in India. And for a moment, I'm not suggesting that it is coming to tomorrow. So I'm not crying wolf to say that estate duty is coming. So set up a trust. All I'm saying is, in certain types of trusts, you can avoid estate duty if properly structured. The difference between a trust and a will takes effect only on death. A living trust takes effect immediately, whereas a trust which is made under the will take effect on the death of the person. Probate, disputes, litigation, yes in the case of a will, no in the case of a living trust made today, because it is done when the person is alive. Control over death possible in case of trust. Trust is possible also during lifetime. Will is never ever possible during lifetime. Estate duty saving possibility in the case of a trust in some cases, and you can plan for minors and mentally challenged beneficiaries. Now, when I say a trust, I'm talking of a private trust under the Indian Trust Act, not a charity commissioner registered public trust. So there will be no income tax exemption, no ATG benefits. Registration is optional, and the trust can own property, investment, shares, etc. Very suitable for married daughters, that is prior to the daughter's marriage, unborn children, minors, handicapped relatives, mentally unstable people, and for pets. Very good idea to set up a trust. What do you have in a trust? You have three elements. You have the settler, that is the person setting up the trust by virtue of a trust deed. He puts in the corpus, that is the sum of money or the asset. He appoints one or more trustees, that is the persons who will manage the trust for the benefit of the beneficiary. So the beneficiary here, the person with the yellow hair, is the one for whose benefit the trust is set up. And the trustee, the person in the tie, is a professional or a friend or a family member who is going to administer the trust according to the wishes of the settler. Trust can own immovable property. It can own land, building, flat. It can open a bank account in the trust name. It can have a PAN or a TAN in its own name, that is a tax deduction account number. But it cannot open a demat account in the trust name, because SEBI does not allow you to open a trust demat account in the trust name, but you would have it in the names of the trustees. So if there is a trust known as Apex Trust, you will not have a demat account in the name of Apex Trust. You will have it in the name of trustee 1 and trustee 2. Bank account would be in the name of Apex Trust. PAN would be in the name of Apex Trust. How do you know this is trust demat account? It would be linked with the PAN and bank account of Apex Trust in the master client DP form, and that is how you know. Trust can also own units of mutual fund. If you want to transfer immovable property to a trust, you need a gift deed for settling land, building, flat, or bungalow on a trust, and it needs to be stamped and registered if the value of the property is more than 100 rupees. Movable property, money can be by issuing a check in favor of a trust, shares by transferring to demat account by a DP slip, and articles of art or artifacts by endorsing certificate to the trust. We also need to bear in mind section 56(2)(10) of the Income Tax Act. First time I'm dealing with income tax in this talk, because it's very important when you look at a trust. There is an exemption that when the person settles any asset on the trust, there is no capital gains on the settler or the donor. But what about income tax in the hands of the trust? There is no tax only if it is a trust created by an individual solely for the benefit of his relatives. That is, the settler must be an individual alone. It cannot be a company. And the beneficiaries must be relatives of the settler. So therefore, the beneficiaries also should only be individuals, because only individuals can be relatives, and they must be such individuals who are relatives of the settler. Now, generally, when we look at exemption under section 56, the donor must be relative of the recipient. That is, we check it from the donee's angle. Here for trust example, a trust exemption, the beneficiaries must be relatives of the donor. So now instead of checking relationship from donee's perspective, we need to check it from the donor's angle. Let me give you a very clear example. An uncle and a nephew are not relatives under the Income Tax Act. Therefore, gift by uncle to nephew would be exempt because uncle is a relative of donee, but gift by nephew to uncle is not exempt because nephew is not relative of donee. So while uncle and nephew are relatives, nephew and uncle are not. It's a very incongruous situation that A is equal to B, but B is not equal to A. But that's how the law reads. However, when we look at a gift by the uncle to trust set up for the benefit of nephews and niece, here the trust would not get exemption, because nephew is not a relative of the donor, which is the uncle. But a gift by a nephew or a niece to trust set up for the benefit of uncle or aunt, here the trust would get exemption because uncle or aunt is a relative of the donor. A little bit complicated to understand at first blush, but when you look at it, it's very clear that the donor must be relative of the beneficiaries of the trust must be relatives of the donor, not vice versa. When transferring property to a trust, consider the SEBI takeover regulations in case of listed shares held as a promoter. Here you need to approach SEBI for exemption, and SEBI has laid down a white paper on what the trust deed must contain, clauses, and therefore you need to ensure that the trust deed contains that. For instance, corporates cannot be trustees, only individuals can be trustees, and therefore that needs to be borne in mind. FEMA regulations in case of non-resident beneficiaries. So if you have non-resident beneficiaries, consider whether you need permission of the Reserve Bank of India. If you want to set up a foreign trust, you can do so under the liberalized remittance scheme of $250,000, but you must ensure that there is no direct or indirect gift to any resident beneficiary. Hence, all the beneficiaries of the foreign trust should be non-residents. Also consider income tax implications of foreign trusts in such a case. Do remember, once an asset goes into an irrevocable trust, it is gone for good. The personal ownership comes to an end. Hence, for an asset parked in a trust, no gift is required, no will can be made, no nomination, no intestate succession. It is out of the person's hands. Coming to gift, a gift is also a mode of estate planning. It is a transfer of existing movable or immovable property made voluntarily and without consideration from donor to donee. So donor is the transferor and donee is the transferee. How is a gift made? A gift deed is a must for immovable property. That is, you would need stamped and registered immovable property gift deed. Deed is not a must for movable property and it can be done by possession alone. Can you revoke gifts? Gifts to their children and then say that the children are not taking care of them. I want to get my gift back. Conditional gifts can be revoked if conditions are not fulfilled as per the Transfer of Property Act. That is, the gift must very clearly bring out it is conditional. However, a completed gift which is not conditional cannot be unilaterally cancelled. So to give two examples, a parent made a gift of a house to their child and now wanted to rescind and revoke it, saying the children were not taking care of them. There was nothing in the gift deed to show that this was a conditional gift. Therefore, courts did not allow revocation, even though circumstances changed subsequent to gift. Hence, if you want to make a conditional gift, get it very clearly drafted in the gift deed. Gifts reserving life interest for donor. So if there is a life interest benefit where the person says, I'm gifting my flat, but I want to use it during my lifetime, that is, I want to stay in it during my lifetime, is that valid? Supreme Court has said yes. Retention of a life interest does not make the gift invalid. So very important that the gift should be very clearly drafted and should bring out any conditionality or any life interest benefit. What is the stamp duty on a gift in Maharashtra? Since I am in Mumbai, I'm dealing it only in the Maharashtra Stamp Act. People in Gujarat should look at the Gujarat Stamp Act. Delhi should look at Indian Stamp Act as applicable in Delhi, and so on and so forth. Gifts attract stamp duty as on a conveyance. Movable property is at 4% and immovable property at 6% on the fair market value of the property. There is a proposal to reduce stamp duty from 6% to 5% because of the COVID scenario, but we have to see the fine print whether it will be applicable to gifts also and what are the conditions. Gifts to family member attract a concessional stamp duty of 3% of the fair market value of property, movable or immovable. And what is family defined as? Husband, wife, brother, sister, lineal ascendant or descendant of donor. Not as wide a definition of relative as under 56(2)(10) of the Income Tax Act. So when the definition is restrictive, you cannot extend it to cousins or uncles, aunts, which are not covered within the definition of family. There is another concessional stamp duty, gift of residential property or agricultural property to 6 relatives, any of these 6, spouse, that is husband, wife, son, daughter, or grandson, granddaughter. The stamp duty is only 200 rupees and the registration fee is only 200 rupees. However, last February, the Maharashtra government came out with an amendment to fund the metro railways, levying a further 1% stamp duty on these gifts also. So now gift of residential property or agricultural property to spouse, child or grandchild in the state of Maharashtra would attract 1% stamp duty and 200 rupees registration fee. So this is what you should need to know when you're looking at gifts of immovable or movable property. We are coming to those, but we have some time, so I'll quickly go over the remaining slides. Guardianship of Hindu minors. The Hindu Minority and Guardianship Act lays down who could be a minor's guardian and how would Hindu minors deal with their property. So natural guardians are the first guardian of a Hindu minor. If there is no natural guardian, guardian can be appointed by court. A guardian can also be appointed under the will of the minor's father, and failing that, the will of the minor's father. So this is all in respect of a Hindu minor. Who is a natural guardian? For a Hindu minor, the father is the first natural guardian, and failing him, the mother. What can the natural guardian do? He or she can do all acts necessary or reasonable for the minor's benefit. However, they cannot create a liability of a personal covenant on the minor. And very important, if there is any transaction of immovable property of a minor by way of a sale or a lease exceeding 5 years, then they need the permission of the High Court. So if they want to sell any immovable property belonging to the minor, they need the High Court's permission. If they want to buy immovable property for the minor, they don't need High Court's permission. So very important to consider whether you would want to make a minor owner of an immovable property, because often it becomes a roadblock that whenever you want to deal with such property, you have to go to court and get permission. Hence, it's advisable to own such property, if at all, by virtue of a trust, so that you don't need to then go to court. Hindu Adoption and Maintenance Act 1956 provides that whenever a natural child, whenever a person is adopted, he becomes the natural child of the adopted family. Now, it's very important that a Hindu male can adopt only with his wife's consent. If he does it without her consent, the adoption is void, and he could adopt a son or a daughter. But a Hindu lady can make an adoption only if she is either a widow or unmarried or divorced. Even with her husband's consent, she cannot make a valid adoption. So very strange and very biased position again. The adoptee, that is the child who is being adopted, must be below 15 years of age. And once adopted, he severs all ties which is natural family of birth. So he no longer is a member of his natural family in which he was born, and he is entitled to inherit properties of his adoptive parents. And from the date of adoption, all the family members of his adoptive parents become his relatives. So his adopted father's brother would become his uncle, his adopted father's sister would become his aunt, so on and so forth. Adopted son becomes son of the adoptive parents. Law recognizes him to inherit property. Even the General Clauses Act considers such a person to be an adopted child. This decision is useful under 56(2)(10) and for claiming concessional stamp duty for gift of residential property. A valid adoption once made cannot be cancelled. We looked at lineal ascendant and descendant when it comes to stamp duty, and we often come across this phase. Is it defined in any law? Answer is no. What does it mean then? It means relatives in a straight line, grandfather, father, son would mean lineal descendants, whereas grandson, father, and grandfather would mean lineal ascendants. So if you are going in a straight line, not horizontal, not diagonal. It would mean ascendancy or descendancy. Does it only include males, or can I say grandmother, mother, daughter, grandmother, mother, son? Yes, it includes females also, either all females or it could be a combination of male female. And we have the Rajasthan High Court decision in estate duty in Dunilal Devi Chand of 1926, where they have said it includes both males and female. What about adopted children? Are they a part of lineal ascendancy and descendancy? While they have not been born in that family on the date of adoption, and from the date of adoption, they become part of the family of the person, and therefore they would also be treated as part of lineal ascendancy and descendancy. And here we have the Andhra Pradesh High Court in Nalli Lakshmi Narayanan, which has said adopted children also become lineal ascendants and descendants. Relative is relative to the law in course. We have 11 laws which define relative differently from each other. Income Tax Act, Companies Act 2013, Stamp Acts, Insolvency and Bankruptcy Code, Foreign Exchange Management Act, Rent Act, Indian Accounting Standards or Ind AS, Benami Prohibition Act, agricultural laws of various states, and SEBI takeover regulation. Each of them defined relatives in a different form. Some of them are more exhaustive than the other. Interestingly, the succession laws don't define the term relative. They use the term legal heir. And as we saw, Hindu Succession Act looks at class 1, class 2, agnate, cognate, and various other types of legal heirs. The term relative does not appear anywhere. So this is a very unique phenomenon that in our country we have at least 11 laws which I could look at which define relative in different manners. Does a son, an adult son, have a right to reside in his parents' home? That is, if the parents are owning the home, can he claim to have a legal right of residency there? Answer is no. The Delhi High Court said if a house is self-acquired by parents, the son and the family have no legal right to live in that house. They can, out of their goodwill, allow him to stay there, but there is no legal obligation on them to continue to bear his burden and his family's burden throughout their lifetime. So if relationships are soured and they are no longer on good terms, then they can take away this right and the son cannot go to court to enforce this legal right. This has been a very interesting and important decision in the context of estate planning. Lastly, Special Marriage Act. A marriage registered under the Special Marriage Act. Now, this is a different creature altogether, not very well known, but it has very unique powers. You can register a marriage already performed under the Special Marriage Act. So if a Hindu marries a non-Hindu and registers the marriage under this law, then the Hindu Succession Act ceases to apply and the Indian Succession Act takes over. So if a Hindu marries a Christian or a Hindu marries a Muslim, the Indian Succession Act takes over if the marriage is registered under this act and the Hindu ceases to be a member of the HUF. It changes the succession pattern not only for the couple, but also for any child born out of such marriage. So even any child would now be governed by the Indian Succession Act. However, there is a twist. If marriages are between Hindus, Jains, Sikhs, and Buddhists, which are registered under Special Marriage Act, then the Hindu Succession Act continues to apply. So it's only if Hindu marries non-Hindu, Indian Succession Act applies. But if Hindu, Jains, Sikhs, and Buddhists marry interstate, then they continue to be governed by Hindu Succession Act. They continue to be members of their HUF. One very big repercussion of Special Marriage Act is for Muslims. Now, Muslims cannot make a will for their entire property. The Shariat law applies, which says they can make a will only for 1/3 of their property. The balance 2/3 goes according to law. So a Muslim cannot say, I give everything to my wife or I give everything to my daughter, because that would be contrary to the Shariat law, that is the Shia or the Sunni law, and he can only give 1/3 to as per the will, balance would go as per law. What if he wants entire to go as per will? He can get his nikah registered under the Special Marriage Act. Once that happens, Shariat law ceases to apply and the Indian Succession Act takes over. So Indian Succession Act allows him to make a will for entire property, and he would now be entitled to give away everything under the will to his wife or to his child or to any other stranger or to charity, in accordance, just as any other person could do. Therefore, this has a very special provision when it comes to Muslim. A question arises, would a probate be required for the will of such a Muslim? Here, there are contrary decisions, and some cases have said yes, and some cases have said no. So we don't have a clear-cut answer on that. But definitely, answer is that a will can be made for the entire property by a Muslim who has registered his marriage under the Special Marriage Act. Important, not required that the marriage should be performed under the Special Marriage Act. A proper nikah could have been done by a qazi. Only after that or before that, the marriage must be registered under this act. Thank you very much, friends, for a patient hearing. Now, if there are questions, we'll take them as in the manner in which Rajesh decides to take them.
Anup, there is a request which you can see on your WhatsApp, which I forwarded.
Okay. Okay. So that
see,
would
because what is happening at Chamber of Tax Consultant, what you have done is Bahubali 1, part 1. Till the queries are not resolved, the confusion will continue. And this time we had 191 live YouTube login and 510 at the Zoom.
Okay.
So it was a grand mammoth session, and all participants are curious to have few of their questions resolved, because this is a tough time for everybody, whether it is professional, and in this tough time, if Chamber of Tax Consultant can help in solving their queries, it would be a great. So subject to your availability, because we have 133 live questions asked on Zoom and more than 40 questions asked on YouTube.
Okay.
So if I compile also, there will be more than 100 questions. And as per the past experience, just resolving your answers in 10-15 minutes will not do justice to your wisdom also. So this was a request which I forwarded to you. Time and date can be changed as per your availability, but a request from Chamber, if you can take, because the questions which has been raised are very valid questions, and it will take a lot of time for analyzing the same, and it will be for the beneficial of all, whether the people who are listening are members, non-members. Over to you, Anup.
So there is one thing I follow. I never say no to Rajesh. So any request from Rajesh is always accepted. So done. 21st is fine with me.
Great. So whoever audience are present over here, 21st May block, same 4 o'clock. That is Thursday to Thursday. Next Thursday, we have valuation of corporates in this tough time. How the corporate valuation has gone for a toss. What will be there? So it is none other than by Sujal Shah, who is the leading personality on valuation. So friends, rather than taking the question today, we will analyze all the question and forward it to the today's speaker. And he has assured, and he is a kind-hearted person who has readily agreed to chair the next session as a speaker. We will all connect again. But with this, I will request Ashita to propose interim vote of thanks on behalf of CTC, MPR committee, and all the 700 participants who are listening to Anup Bhai.
Just one question before you do that, Rajesh.
Yes.
Would you be compiling these questions, or how would it be taken? So
no, we will be compiling the questions and forwarding to you, whichever you find interesting, because in a 2 hours time, we understand you will be able to take 40 to 50 questions.
Right.
So we will be giving you the questions. Who has raised the question is irrelevant. What is important is the content of the question.
Fine. Okay. Thank you.
Okay.
Okay.
Ashita,
it is my proud privilege to cast vote of thanks on behalf of Chamber. Sir, please accept our heartfelt gratitude for sparing your valuable time and enlightening our participants on the topic. The way you took us through the case studies was really commendable. Thank you once again. And we will surely meet up for the second part on 21st. On behalf of MPR committee, we are also grateful to CA Maitri Chheda, Chairperson IT Connect, for all the technical guidance and support. Thank you, Maitri. And thank you, everyone.
Thank you.
Friends, as a concluding remark, personal thanks to Anup Bhai for readily agreeing for the next session, and all who are listening, please become member of Chamber of Tax Consultant. You can go online and make the payment. Thank you very much. See you soon again. Have a good day. Stay connected. Stay safe.
Bye.
Rajesh bhai,
Bye.
Yes, Maitri Ben.
have you taken down all the questions?
Yes,
Yes.
all questions are taken.
Okay, then I will end the session. Thank you.
Yes. Thank you.
Thank you.